No, you can't. I got 6 exams today and I don't need to hear the same stuff 4 times. Ask a new question that elicits new information. So maybe you got to ask her specific questions about threats or violence. Okay, ma'am. I don't know, maybe you've never watched a show on TV where there's a trial, but when an attorney stands up and says object, the witness doesn't talk.
Okay.
She said she stepped out of the front door onto the porch. Your client came out and they had the confrontation on the porch.
We are.
Oh, G. All right, let's have appearances on G.
Thank you, Your Honor. Stephen Kaplan on behalf of the people.
Thank you, Judge Okklay, Zachary Hallman on behalf of Ms. G, who's standing to my left.
All right. Thank you. Have a seat. Are we ready?
Yeah, Your Honor, this will be following one word.
All right, let's get going. All the way up front, ma'am. All the way up here. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth today?
Yes.
Watch your step on my incline ramp right here. Settle in that chair. Once you're seated, go ahead and state your name and spell your last name.
My name is Tammy Fixby. My last name is Highsby.
Thank you.
Yeah. Good morning, Ms. Sixty. Where do you live?
I live in
What is your address?
35514 Golden Boulevard, Romans, Michigan.
Do you know a woman named Jakina G?
Yes, that's my neighbor.
If you saw Jakina G again, you think you'd recognize her?
Yes.
Look around the court and tell the judge what you see.
I see that.
What is she wearing?
Green sweater.
Your Honor, may the record reflect the witnesses identified this evening.
Noted.
Thank you, Your Honor. Without going into a long story, I just want to know how long have you known this?
I don't really know her. I never really talked to her.
Had you seen her before this date,
Yes.
January 8th,
Yes.
2026?
Yes.
Can you tell the judge the number of times you had seen her January 8th, 2026?
Like we just meet outside.
It could be in person, it could be outside, it could be through a car, so many times you see it.
I've seen her a lot.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What starts as a dispute between neighbors is about to turn into a serious courtroom battle over whether a threatened use of a taser qualifies as felony assault. Pay close attention, not only to what the witness says, but also to how the attorneys frame every question. In court, the smallest detail, like distance, fear, and intent, can determine whether a case moves forward or falls apart. Do you think the prosecution has enough evidence? Or will the defense expose reasonable doubt? Let's see how this unfolds.
Now, regarding the date of January 8th, 2026, around noon, did anything unusual happen?
Yes.
What happened that was unusual?
I was threatened with a taser.
You were threatened by a taser, by whom? With a taser by whom? Where were you and where was Miss G when she threatened you with the taser?
I was by my front door, and she was by her front door.
How far do you live from her?
Like 3 steps away. We share the same wall.
You said you were threatened with the taser by Miss G. What do you mean by that?
She brought a taser outside and was zapping at me 3 times and was telling me that she also had a gun inside. She couldn't use it out.
But what did she do with she were pointing the taser at you?
Yes, she pointed at me.
Can you estimate for Judge Okklay the number of feet between you and the defendant G when she pointed the taser? With the judge's permission, I'm going to walk towards you
Go ahead.
Not gonna invade your space, but stop.
Right there.
Judge, may the record reflect a distance of about 6 feet?
Counsel, you agree? About 6 feet?
Well. Your Honor, excuse me, I'm sorry. Your Honor,
That's all right. You don't have to jump up for me.
I'm not sure that I can agree because, distance is an element, we believe, of the case that we're not gonna sit.
Okay.
It's the actual distance.
I would say it was approximately 6 or 7 feet. Move on.
Thank you, Your Honor. Can you describe the case?
It was about that long, like we were just like this, it was, and then it would like kind of went like that. Kind of like the big old ones,
Did you tell me the color of the case?
black.
What were you thinking when she pointed the taser?
That she was gonna use it on.
Did she use that?
No,
How does this end? You said she pointed the taser at you and then what happened?
I went inside and I had to go out my back door to be able to leave. Because every time I went out my front door, she would start up again.
What were you thinking and feeling? Taser was pointed at you.
I was scared for my life.
Thank you, Your Honor.
Mr. Holman.
May I approach, Your Honor?
Sure.
Thank you. Ms. Sigsby, how are you this morning?
I'm good, how are you?
I'm doing my best. I'm Miss G's attorney. And my name's Zach Coleman. I have a few questions for you today as well. If you don't understand the questions I have, which is entirely probable, just re-ask or ask me to re-ask the question, please. Don't try to guess. Mr. Capel will take care of you in that regard too. Isn't it true you lived as Miss G's neighbor for over 3 years?
Yes,
And in that time, since you've lived with her, is it fair to say that there was a period where you were more amicable with her than you are now?
Factor relevancy doesn't establish an element of the crime or disprove an element of the crime. They can be best friends or mortal enemies.
If, Your Honor, if I may continue with the line of questioning, you'll see where I'm going with this.
Without a response to the relevancy objection?
I think it's entirely relevant. It goes to the reason that the complaining witness made the call to the police. It goes to the nature of why the matter escalated in the first place that day, as to what she saw, as to what other complaining witnesses saw. I think to narrow it down to the element of whether Miss G had a taser that day or not is a little too narrow for the scope to that response.
Your Honor, she either pointed the taser at her or she didn't point the taser at her. That's what we're here to discuss. We're not here to determine whether they're best buddies or mortal enemies.
In fact, though, Your Honor, we are, because one of the essential elements of this crime is whether Miss Sigsby was truly afraid for her life. So if she doesn't know her at all, as she testified, or whether she does know her, and this is just an issue between the two of them, where she knew that Miss G was actually not going to go retrieve a gun and fire it at her, but it was a continuing issue between the two of them, then that does impact Miss Sigsby's state of mind, whether she was in fear of her.
Go ahead.
Sorry.
No, you're all right. Go ahead.
Once assault can be proven one of two ways. It's either the attempted battery or an attempt to place somebody in fear of suffering a battery with a dangerous weapon. So I don't see how this inquiry, and I must agree with this inquiry proves or disproves anything controversy. Might be interesting. Maybe a jury wants to hear the details, but you don't need to know those details.
Then, Your Honor, it goes also into Miss G's state of mind. And whether how well they know each other, it is absolutely relevant to what Miss G intended that day.
I don't think her state of mind is relevant at all. It's whether or not the alleged victim was put in fear.
Well, then I stand by my previous response. I do think that the level to which she knows Miss G, if she had just moved in, she's never seen her before, or if she's seen her as her next door neighbor for the last 3 years, is relevant as to whether she was in fear for her life.
I'll allow very limited questioning on that specific issue. What this witness knew about that lady's propensity for threats or violence, because that's what you're saying.
Thank you. So Ms. Higsby, let me back up before we got a little sidetracked. I think my last question was, you lived next door to Ms. G for 3 years, or over 3 years, right?
Yes.
And so over that time, how many conversations have you had?
Probably
Objection
five,
as to relevancy.
Probably 5.
like five or
Okay,
Sharon's talk.
all right. How many conversations she's had?
Oh,
You don't talk, because I'll remove you from the courtroom. The issue is whether or not she thinks this lady has the ability to make it, if a threat is serious, that's what you were relying on, right? Okay, so whether or not they've had 40 conversations or 4,000 conversations doesn't get you there. Not in a limited light of questioning. So maybe you got to ask her specific questions about threats or violence.
Has Miss G ever before the date that we're talking about here made any threats towards you?
Objection. It's not relevant on the day in question, that's what we're concerned with.
I'll allow it. I'll allow it on a limited basis.
Yes, before the date in question.
I wouldn't say threatening,
Okay.
that I know, like, I didn't know her like that. The first time I met her, she called the cops on me. Because she said I parked in her parking spot. I've always tried to stay away from
None of
her.
this is relevant.
Yeah, let's move on.
I did not.
Okay, there's no question.
Okay, Your Honor, I believe Mr. Cavan interrupted when she was answering the question that I posed to her. And
She was talking about your
This is one of those courtroom moments that every viewer can learn from. The judge isn't simply correcting courtroom etiquette, he's protecting the integrity of the trial. When an objection is raised, witnesses must stop talking because the judge has to decide whether the answer is legally admissible before the jury or court hears it. Notice how frustrated the judge becomes with repeated objections and repeated questioning. At the same time, the defense is trying to establish whether the witness had prior reasons to fear the defendant, while the prosecution argues those details don't prove the charged offense itself. Which side do you think is making the stronger legal argument here?
client calling the cops on her because of a parking violation.
right, and I believe before that, you were talking, you said that you've had about 5 conversations.
Very limited conversation.
Well, I'm asking you about those limited
And
conversations.
we object as to relevance.
And in those limited conversations, your testimony is before the day that we're testifying about today, she had never made a threat towards you.
Objection as to relevancy is not an element of the crime.
I'm allowing it.
She has not threatened me, but she has done stuff to try to provoke me. That's what she always has been doing, and I kept forgiving her. I just want peace.
What was she doing to provoke?
Objection.
I never done my door.
Okay. Okay, ma'am. I don't know, maybe you've never watched a show on TV where there's a trial. But when an attorney stands up and says object, the witness doesn't talk.
Okay.
Okay? Make your objection. Response.
Your Honor, I think if I can request for an instruction, if we're gonna get the same objection, please have on every single question. It is an essential element of the crime. I am keeping my question very limited to what you narrow the scope of this line of questioning to, and we're still getting an objection every time. It seems like we're clearly trying to interfere with the complaining witness's testimony. I'm asking very specifically about her frame of mind on that day. That is contextualized by the history she has with my client.
I'll allow it.
What would my client be provoked?
Your hamburger on my front door after I went to work.
When did that happen?
Your Honor, we object these are prior bad acts under 404B, and they're being introduced against her, this client.
If he wants to introduce him, let him. I get to decide that today.
And she has followed me. I've had a police report after what happened. because she was following me and my daughter twice.
And when in proximity to the day in question that we're testifying about today, did the two incidences that you just described, to the best of your memory?
When did they happen?
Yeah.
About a week ago, 2 weeks ago.
Okay, so did this, my initial question was, times you interacted with Ms. G, my client, before the day in question. Okay.
Jack, it's been asked and answered, and it's also not relevant.
And it's confusing. So this incident happened in January. Yes, ma'am?
Yes,
The taser incident.
yes,
The incident with the hamburger and the following, was that before January or after January?
before.
Okay, about 2 or 3 weeks before?
No, about a year.
Move on.
Okay, so any other incidents of provocation that the term of use from my client besides the hamburger, I don't even know the incident of stalking where you call police?
Since after,
Before January.
Well, I'm sorry, before June.
there was incidents where she would be like trying to provoke me, or she would try to get information out of me, apparently, because of the stuff that she was saying on the day of the incident, of information that she knew, and the only way that she would know that information is if she was following.
Okay. Yeah. My initial question, yes, I agree with Mr. Dickens, it's no longer relevant. But just to close this line of questioning, was there any other incident with the, let me re-ask, besides what you've already testified about, before the incident in January, did you have any other interactions with my client where she either provoked you or allegedly threatened? Okay. Were you looking for a reason to call the police on Ms. G?
No,
Why did, on the day in question, in January, isn't it true that your mother-in-law was involved in these?
Jack,
Or
that's the problem.
I don't have a mother-in-law.
the,
Objection, ask
Okay.
the see.
Okay.
Doesn't prove or disprove anything in controversy.
well, actually, Your Honor, the response is, I'm moving to the day in question. And there is another witness, and I'm sorry, it's a familial relation, and I'll correct the record. But absolutely, she was involved. She bore witness to Miss G being there. And my line of questioning is about where ultimately the complaining witness was when the alleged threats were.
We have a trial within a trial here.
Yeah.
Feeling
And
that-
she's already testified that they were approximately 6 or 7 feet away when the taser was involved. So I don't know what more you're going to get about proximity.
Well, then let me narrow it down, please, Your Honor.
Try.
Thank you, Your Honor. It is, my line of questioning is specifically, where were you in terms of your proximity to your doorway of your apartment when Miss G allegedly threatened with her taser, alleged taser?
I was on my front porch, next to my front door, by the farthest, like right here. So I just walked out.
You had just walked out of your porch.
I just walked out of my house.
Onto your front porch.
Yes, onto my front porch.
Thank you.
Wow.
So you had just walked out of your house onto your porch,
Jack, has been asked and answered.
It is. Go ahead.
and was that the first time you saw Miss G with what you believe was a taser?
Yes, because she's acted at me.
Hold on, if you could just answer the questions that I asked you, please. When did she zap it?
She walked outside. She walked outside screaming, talking about she had a gun in the house. She was going to shoot me with it, and she had the taser in her hands, and she zapped it 3 times that day.
Okay, that was when you came out of your house.
Yes.
So
Your Honor, excuse me.
where was it?
I'm being distracted by the.
I'm going to put you in a lockup. If you can't sit there without making any noise, you'll be removed from the courtroom. Do you understand that?
Okay, so my question really was, when did Ms. G threaten you with the taser? Was it before you went into your house? After you went in, you came back out of your house, both?
She said she stepped out of the front door onto the porch. Your client came out and they had the confrontation on the porch.
If I may,
No, you can't. I got 6 exams today and I don't need to hear the same stuff 4 times. Ask a new question that elicits new information.
okay, where was Ms. G when she threatened you with the taser?
On her front porch.
Where in proximity to your house is her front porch?
Hashtag studio microphone VO3. Insert after timestamp 2114, immediately after bound over. AY is next week 9 a.m. Thank you. The judge has made the key decision in this preliminary examination. The case will continue rather than end here. That doesn't mean the defendant has been found guilty. It simply means the court believes there's enough evidence for the prosecution to move the case to the next stage. Throughout this hearing, we saw sharp arguments over relevance, witness credibility, and whether the alleged use of a taser met the legal standard for a dangerous weapon. We also witnessed a judge determined to keep the courtroom efficient by shutting down repetitive questioning and unnecessary interruptions. These procedural rulings often shape a case, just as much as the testimony itself. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Like
6 or 7 feet away. Sit down. You're done with cross. Do you have any redirect?
Oh, wait.
Thank you.
Put my objection on the record.
Feel free. Any other witnesses? Any defense witnesses? Any argument?
Yes, Your Honor, the witness testified a taser was pointed at her distance of 6 to 7 feet. She was afraid, actually fearful for her life. Thank you.
Your Honor, we don't believe the elements of felony assault with a felonious weapon occurred here. We believe, if anything, the charges should be dropped to misdemeanor assault. And we ask that you would find that the prosecutor did not meet his threshold for a preliminary exam and would not find so. Thank you.
Because there was no testimony about a felonious weapon?
Your Honor.
I'm not familiar with what a felonious weapon is.
Your Honor, I would have gotten into more details regarding what Mrs. What our lovely complaining witness perceived the weapon to be. I will reserve that argument for circuit court. I don't believe that it's a felonious weapon in this case.
Okay, I don't even know what a felonious weapon is. Is that the same thing as a dangerous weapon?
I don't believe that it meets the definition of a dangerous weapon, making this a movie structure.
Okay. Bound over. AOI is next week, 9 a.m.
Thank you, Your Honor.
Say again? What? Oh, yeah, you can step down, man. Watch your step. What is today?
Today is the 19th.
Yeah, so 26. No. Yeah, yeah. No, she's in custody. Oh, she not? Oh, she had green on. I thought. Okay.
DOC could be dismissed, so we can pull that when we get it done.
Who? What's the name? Okay, what about Avant, that's 9:45? Avant, 9:45.
I was going to get into, I bet she's very close, ready to go.
Who?
Steps up in.
You just get her in here. So it's going on an hour.
Yeah, it's good, going on.
Uh, who changed the date stamp today to the 20th?
I'll throw on the question, Joe, to do his problem himself. Here, you're right.
I know, okay.
Hey, Carrie, how are you? Better than I deserve, Carrie.
Avant, Judge.
Appearances on Avant.
Good morning, I got 12, 8, 5, 6, 8, 9, and then Mr. Rogers to take any directly.
Good morning, sir. Counsel, you got a plea worked out? Tell me about it, please.
Unlawful transport and dismissal of the original one on it,
Yeah, we only had one count, right? All right.
no comments. And I.
That was my next question. All right, sir, do you understand your rights and your options after discussing same with counsel? And you understand the possible penalty for the added charge? All right, and understanding that you're pleading no contest today, is that correct? Do you understand that when you say no contest, you're literally saying to me, Judge, I'm not fighting that charge? You understand that? All right, counsel, I've got an incident date of April 6, 2025. If you can get me the facts I need.
Thank you, Your Honor. Your Honor, if this case were to proceed to trial, the people would be able to show that on April 6th of 2025 on Ecorse Road and Harrison Street in the city of Romulus, County of Wayne, state of Michigan, that Andre Avant did possess a weapon in a motor vehicle without the proper permits or licensure to do so. And transporting that, not according to law.
Okay. Mr. Kaplan, you satisfied?
Yes, we are thinking,
Factual? Court satisfied. I'll dismiss the original count one felony. Any reason not to sentence right now?
it's sensing.
All right. Tell me something about your guy.
Court would consider fines and costs in this matter. My client's only criminal history is from 22 years ago. He owns his own business. He has a partner. He has children. He has been a law-abiding citizen except for it, which he's told me he was in possession of this out of state. Realized when he brought it back from that trip that the laws differ state to state, since he was able to pick this up in a gift shop. So now that he knows that, this won't be happening again, Your Honor.
Okay. What's your business? I'm sorry. Go ahead, Mr. Kaplan.
See, Kevin, thank you. At the age of 47, he has no criminal record other than these offenses that happened 22 years.
Yep. I think he just took your side.
Judge, we're recommending.
What business are you in? What do you do? Okay. Okay. Who do you deliver for? Are you one of those guys like delivers for Home Depot and stuff?
Well, whatever, yeah.
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 Okay. Okay. All right. Don't feel that you have to, but is there anything you want to tell me before I sentence you?
No.
All right. Counsel, anything else?
Your Honor, I think this one.
I do too. All right, fines and costs are $500. Can you pay it today, sir? Or do you need to talk options? Go downstairs and talk about your options. All right, felonies dismissed. Have a good day, counsel.
Thank you, Your Honor.
You're welcome. What do we got next? And appearances on Hadley.
Stephen Kaplan on behalf of people.
And good morning, Judge Okklay. Good morning to your staff. David Defense Service, Perry Markin, P 84592, representing Devontae Hadley, sitting to my left. Telly for.
Thank you. Sit. You're all right, sit. We holding?
I mean.
Yeah.
I'm here with Detective Mays. He has made yeoman-like efforts to produce our witness. We're both disappointed the witness is here. I don't want to waste your time, Chuck. Would you mind if you just stated on the record the efforts he.
Yeah, go ahead, detective.
I reached out to one of the enterprise personnel people based on they were with this case. That employee no longer works there, and they had a relatively common name. Therefore, I was unable to locate them through every database that I use. The party involved, I believe, actually was a third-party contract that was transporting the defendant, and I contacted him. Did speak. He was a little standoffish, if you will, and asked me to call him back, which I did, and he never answered. So all attempts have failed. My apologies for that.
All right. Motion?
There are obviously the people not ready to proceed. We would move for dismissal without prejudice.
Dismissed without. Good luck. Thank you.
So on the strangler case,
Mhm.
we've got a victim,
Mhm.
no defendant. And
That's curious too. Okay. Yep.
I don't know if we have the attorney.
Hey, Carrie. Any contact with Stringer?
She should be here. She told me she had a flat.
Ah, okay.
Yeah.
Okay. But you've been in contact.
Yes.
Okay. What about Fonville in custody, right?
He's in custody.
We're just
I don't know
waiting
if
for the attorney?
it's yeah.
Okay. All right. Thank you. Oh, that's right. She's a retail fraud.
The courtroom turned tense when the judge lost patience with repeated arguments and interruptions. After hearing the same points over and over, the judge firmly cut the attorney off, saying, "No, you can't. I got 6 exams today and I don't need to hear the same stuff 4 times. Ask a new question that elicits new information." Moments later, the judge warned another participant, "If you can't sit there without making any noise, yes, you'll be removed from the courtroom." The judge maintained strict control, refusing to allow unnecessary delays and making it clear that the proceedings would move forward without repeated arguments or distractions.